All right, good morning. Can both of the attorneys hear me?
Yes, Your Honor.
All right, good morning. Welcome to the session of the 5th District Court of Appeal. I'm Jamie Grosshands. I'm joined today on this panel by Judge Harris and Judge Traver. I just remind the attorneys that this broadcast is live and also recorded. Can both attorneys see the clock?
Yes.
Okay. I will reserve 5 minutes for rebuttal for the appellant, but if you'd like more, the clock can be adjusted. So at this time, we'll call case 19-137, which is Robert Ollinger versus Deutsche Bank National Trust Company. Appellant, you may proceed.
Good morning, Your Honors. May it please the court. My name is Mike Brownlee. I'm here on behalf of the appellant, Robert Ollinger. And so, Your Honors, this is a foreclosure appeal, as you know. The issue on appeal is whether the trust introduced sufficient evidence at trial to establish that it had standing at the inception of the suit, at the time it filed its complaint. Our position is the trust failed to carry its burden of proof at trial, and here's why. We've got, when the trust filed its complaint, it attached a copy of Mr. Ollinger's note that does not have any endorsements. Then about a year later, the trust files the purported original of the same note, and it does contain endorsements. And this court's decision in Madel and other decisions that we cited in the briefs make clear that under these circumstances, for the trust to establish standing, it needed to elicit testimony at trial to explain the discrepancy between the copy of the note and the original, and to prove that it actually had possession of the endorsed version of the note at the time the complaint was filed.
Mr. Brownlee, distinguish your case factually from the Marciano case, at least with respect to the PSA and the MLS and the evidence that was submitted at trial in that case.
Well, I think Marciano would be similar to our case, but for the fact that in Marciano there's no conflict between a copy of a note attached to a complaint that conflicts with a later filed original like we have here. And I think Madel makes clear, and Madel distinguishes Marciano on those grounds, if I'm not mistaken. Now, the trust, of course, disagrees with Mr. Ollinger's position, and according to the trust, it established standing in two ways. First, the trust says that the note was endorsed prior to the complaint being filed because its witness, Ms. Tramble, testified that based on section 2.01 of the PSA, which requires notes to be properly endorsed to the trust prior to it being included in the trust, that by virtue of that clause being in the PSA, it must mean that the note was in fact endorsed before it went into the trust. The problem with that is that just because a contractual clause says something is supposed to happen does not mean that it actually happened. It's not proof that it happened. The second argument the trust presents is that it had constructive possession of the endorsed note based on the Bailey letter. And I think it's important to take a step back here. If the trust is correct that the former servicer of Mr. Ollinger's loan sent a copy, the original version of the note with the endorsements on it 2 days before filing the complaint, then why would there be a copy attached to the complaint that doesn't have the endorsements? Why would the trust include a lost note count if it had physical possession of the endorsed version of the note? And in addition, we have
is the issue physical possession, or if it's a Bailey letter by that very definition? I mean, if it's in the hands of an authorized agent, and I don't necessarily know that you dispute the agency status of the bailor. Yeah, so if it's in the hands of an authorized agent at that particular point, why does it matter whether or not the trust had actual physical possession of the note at the time the complaint was filed?
Well, it's possession of the endorsed version of the note. That's what's important. And I think the evidence at trial, I think what you can infer is that the whatever was transferred from the former servicer was the version of the note that was attached to the complaint. It didn't contain the endorsements. And the Bailey letter itself is problematic also because, you know, there's a return acknowledgement signature line that the attorney is supposed to sign when it receives the note. And Ms. Tramble testified that general practices are that that would be signed if the note was received. And in addition, we've got the activity logs, which don't reflect any receipt of the note or sending of the note, endorsed or otherwise, to the trust prior to filing suit. And again, Ms. Tramble testified pretty clearly that the general practice would be that it would be reflected in those activity logs if in fact that had happened. So our position is that this court should reverse and that this case falls squarely under Madel, and that should control the outcome of this case.
How would you best distinguish this case from the 4th District's case of Bolus?
I think that's
very similar.
Yeah, that's the closest one. I mean, I think our case is distinguishable because there's a case Friedel that came out after Bolus, and it distinguishes. It's helpful in that it says, you know, in Bolus there was sufficient testimony that the loan was included in the trust based on the witness's testimony about the PSA and the knowledge of the witness's knowledge about the PSA and the MLS. And in this case, we don't have sufficient proof that the loan was actually included in the trust. Like in Madel, we've got a PSA that's unexecuted, and the MLS doesn't reflect Mr. Ollinger's loan number or his name, and there's no tie-in back to that PSA. So our position is that Ms. Tramble's testimony about those documents is not sufficient to prove that it was included in the trust, whereas in Bolus it was. Unless the court has any other questions, I think I'll reserve the remainder of my time.
Thank you. Ms. Mello, you may proceed.
Thank you. Good morning. May it please the court. My name is Kim Mello, and I represent the trustee in this matter. As counsel stated, the sole issue in this appeal is whether the trustee presented substantial competent evidence of its standing to foreclose at the time the complaint was filed. I think the standard here is important. It is competent substantial evidence. This court is not here to reweigh the evidence and act as a fact finder. That's already been done by the trial court. So the role here is just to determine whether or not there is in fact legally sufficient evidence in this record. And you know, you'll find these in numerous foreclosure cases. This is not an unusual situation where the copy of the note that is attached to the complaint is not endorsed, and sometimes you'll have situations where there's actually no note that's attached to the complaint, and the endorsed note is later produced and it is admitted into evidence at trial. When you have this situation, you know, there's two things that the plaintiff has to prove. One of them is that the original note was endorsed prior to the complaint being filed. And the second thing that the plaintiff has to prove is that the trustee or its agent had physical possession prior to the filing of the complaint. So those are two things that the courts say have to be proven. And that's just based on the UCC definition of what constitutes holder status. It's those two things that are controlling. Under this court's precedent, the trustee clearly met its burden. Marciano is controlling, you know, and in that case, there was no note attached, but the evidence that was adduced at trial in Marciano, very similar to this case. You have the original endorsed note. you have the pooling and servicing agreement, and you have the mortgage loan schedule. Those all were also introduced into evidence in this case. In this case, the pooling and servicing agreement was admitted without objection. The plaintiff is clearly the trustee under the PSA. The PSA contains the key section 2.01 language, which requires that there be a chain of endorsements from the original lender, and then that chain of endorsement end with the note being endorsed and blank. And also in the section 2.01 language, you have the language saying that the mortgage loans, okay, have to be placed into the trust as of the closing date. The closing date in this case was April 1 of 2006. In addition, like Marciano, the witness did testify on this issue. And the testimony was pretty clear. I mean, it's at page 52 to 53 of the transcript itself, and what the witness said, the question, the two key questions, and these were her answers. It was, and this loan was included in the trust prior to the closing date pursuant to the testimony relying on the MLS, the mortgage loan schedule. Is that correct? That is correct, yes, was the witness's answer. So therefore, we know that the note must have been endorsed before the suit was filed, correct? And she says, that is correct, yes. So based on the pooling and servicing agreement, which had the section 201 language, based on the mortgage loan schedule, which listed the borrower's loan, and based on the witness testimony, which confirmed that in fact, the loan had been placed into the trust in 2006, which was 3 years before the filing of the complaint, that was competent substantial evidence of standing. This court in Marciano said that the PSA demonstrated that it had, and when I say PSA, it's the pooling and servicing agreement, demonstrated that it had possession of the blank endorsed note at the time the complaint was filed. And the court looked to the witness testimony that made clear that the loan became a trust asset prior to closing, that it predated the complaint. So from our standpoint, Marciano is controlling, it's on point, and really, I mean, it really can't be distinguished. The borrower heavily relies on the Medall case, also out of the 5th DCA. And, there's 3 key differences between Marciano and the Medall case. So, in Medall, you have witness testimony where the witness clearly did not know when the endorsement had been placed on the note, okay? Here, based on the testimony that I just described, that's not an issue here. We did have witness testimony of when the endorsement was placed on the note, relying on the PSA.
Well, counsel, I think what the opposing party has pointed out is that the witness seemed to rely on the fact that the requirement, that there was a clause requiring it to be placed in there, not necessarily that she had knowledge that it had been placed in there. How would you respond to that? Because there was some conflict in her testimony.
Right, there's clearly some conflict in her testimony. I agree, those are conflicts that the trial court resolved. But when you look at the cases, and I believe that it was the court in Marciano, okay, noted a footnote in this court's decision in Schmidt, and it basically said that the Schmidt decision, which the court ruled that there was no standing, that one of the critical differences, okay, between Marciano and the Schmidt case was that it was unclear if the PSA had the section 2.01 language. So that language, even this court has looked at. I mean, a lot of times, I mean, these witnesses don't have, you know, personal knowledge of these trusts and the process. So they have to rely on their business records. They have to rely on the language of the trust. I mean, this happened back in 2006. I mean, there's no court that I'm aware of that has imposed the burden that opposing counsel has suggested, you know, to establish standing. And you know, one of the problems with the Medall case with the PSA was that it was unsigned, and the problem the court had with it was that it came from the SEC website. Here, there was testimony. We laid the foundation under the business records exception to the hearsay rule. And we also went through the boarding process to show that all records that were transferred from the prior servicer to the current servicer, which was Ocwen, were all verified for accuracy. So when in the Medall case, they didn't want to rely on the PSA, okay, because of the fact that it was just something that was printed out from the SEC website. And they found that made it just insufficient evidence. And also the key difference with the Medall case is that there was no mortgage loan schedule. And the courts, if you look at the line of cases on this, the courts have found that this mortgage loan schedule it's critically important, right? Because you have to know that the borrower's loan was actually placed into the trust. So in Medall, there was no mortgage loan schedule. So there was no way to determine whether or not the mortgage loan schedule had actually been placed into the trust. I mean, that was a significant deficiency in Medall that's not present in this case, that makes it distinguishable. You know, and then on the issue of the Bailey letter, you know, the Bailey letter in this case is really, it's just additional evidence of possession is what the Bailey letter shows. And of course, under the law, possession can be either actual or constructive. Here, the Bailey letter showed constructive possession by the servicer just prior to the filing of the complaint. The Bailey letter was dated May 29th of 2009. So that's when it was actually, that's when the servicer actually had the original endorsed note, right? We know that they sent it to counsel for the filing of this foreclosure action. The foreclosure action was filed on June 1, 2009. I mean, we don't know for certain, but when you look at the dates, May 29th versus June 1st, it's likely that counsel just didn't have the original endorsed note at the time that they filed this complaint. But what we do know is that the counsel that was sent the letter with the endorsed note was that they actually then filed it about a year later on June 2nd of 2010. So the Bailey letter shows that the servicer had constructive possession of this note as of May 29th, 2009, just prior to the filing of the complaint on June 1, 2009. And a lot of times with these cases, you know, what you'll see that, you know, there's the servicer either always holds possession, or sometimes the trust will hold possession, and then they'll have to transfer it down to the trustee. Really doesn't matter in this case, because here we know that the servicer had possession of it prior to the filing of the complaint. And so those were, I think, the primary points that I wanted to make to, you know, distinguish Medall and show why, you know, Marciano is clearly, you know, controlling, you know, in this particular case. I mean, there was clearly legally sufficient evidence, and that's all that's required for this court to affirm the final judgment. And if there are no further questions, I conclude my argument.
Thank you.
Thank you.
Your Honors, I think what's important to keep in mind here is that just let's assume for the sake of argument that the trust established that this loan was included in the trust. That doesn't, you still have to prove that you have possession of the endorsed note. And I'll read a quote from Perez, which is out of the 4th DCA. Evidence that the note was physically transferred into a trust prior to Deutsche Bank filing its foreclosure complaint does not by itself establish standing. A plaintiff must prove not only physical possession of the original note, but also, if the plaintiff is not the named payee, possession of the original note endorsed in favor of the plaintiff or in blank. So our position is that the PSA and the MLS are much ado about nothing unless the trust is able to point to evidence that shows they had physical possession of not just a note or a copy of the note, but the endorsed version of the original. And I think that's dispositive here, at least in terms of the trust reliance on the PSA and the MLS. And I'd also remind the court, the standard of review is de novo. Yes, you're reviewing for competent substantial evidence, but there were no findings below that this court needs to defer to. And this court's review is de novo because it's standing in a bench trial and also because Mr. Olinger moved for an involuntary dismissal. And other than that, unless the court has any further questions, I think we'll rest.
Great. Thank you, attorneys, both of you. We appreciate this, and this will end the session of today's argument.
Thank you, guys.
Thank you.